I'm going to talk today about conduct prejudicial to good order and service discipline, as set out in the Armed Forces Act 2006. Now, by way of background information, the Armed Forces Act 2006 was passed in order to bring together the various pieces of legislation that provided for service offences within the Royal Navy, the British Army and the Royal Air Force. So it was a piece of legislation that brought all three together into one single statute. Now, conduct prejudicial to good order and service discipline is just one of the offences set out within the Armed Forces Act 2006. However, the offence of conduct prejudicial to good order and service discipline is particularly interesting, one, because it is used frequently, and two, because its definition is missing. It doesn't actually say what conduct prejudicial to good order and service discipline is. In order to consider that, you have to go way back into history. It wasn't even set out in the Army Act of 1955. So precisely what constitutes conduct prejudicial to good order and discipline seems to be largely subjective, but it hasn't really been defined by legislation. The legislation sets out the punishment, but it doesn't actually set out what conduct prejudicial to good order and service discipline is. It simply says that it's to be an offence. So let's consider Section 19 of the Armed Forces Act 2006. This is conduct prejudicial to good order and discipline. And you will note that the offence is not actually defined. It's not defined what might be conduct prejudicial to good order and service discipline. But anyway, the offence itself, Section 1, a person subject to service law commits an offence if he does an act that is prejudicial to good order and service discipline. And as I said, you will note that actually what good order and service discipline might be and what conduct prejudicial to it might be has not been described. Section 2. In this section, act includes an omission, and the reference to the doing of an act is to be read accordingly. And this means that it can be something that is done or something that is not done. And finally, Section 3, a person guilty of an offence under this section is liable to any punishment mentioned in the table in Section 164, but any sentence of imprisonment imposed in respect of the offence must not exceed 2 years. And I'm going to provide a copy of the table in Section 164 to go through. Section 164 of the Armed Forces Act 2006 sets out the punishments available to court-martial. There are a total of 12 different types of punishment available at court-martial, so let's go through them. The first is imprisonment, but this can be split into two parts. The standard meaning can be imprisonment within the civilian prison system. However, it is also possible to order a period of detention at MCTC in Colchester, and that is separate to imprisonment. MCTC will accept detainees for up to a maximum of 2 years. The second punishment available is dismissal with disgrace from Her Majesty's service. And the third, slightly less serious, dismissal from Her Majesty's service, and you will note that that is not with disgrace. The fourth, as I've mentioned already at 1, is detention for a term not exceeding 2 years. That is at MCTC in Colchester, but note that that is not available for officers. It is only available for enlisted ranks. 5, forfeiture of a specified term of seniority or of all seniority, and that is only available if the person being sentenced is an officer. 6, reduction in rank or disrating. This is only available if the person being sentenced is a warrant officer or non-commissioned officer, and it's not available to an extent prohibited by regulations. 7 is a fine. 8 is a service community order, but this is only available if the person being sentenced is on the same occasion sentenced to dismissal or dismissal with disgrace, and subsection 5 permits. 9 is a severe reprimand or a reprimand, but this is only available if the person being sentenced is an officer, warrant officer or non-commissioned officer. 10, a service supervision and punishment order, but this is only available if the person being sentenced is an able rate, a marine, a soldier or an airman. 11, such minor punishments as from time to time be authorised by regulations made by the Defence Council. And 12, a service compensation order. So it is anticipated that most offences of conduct prejudicial to good order and service discipline will be dealt with at summary hearing by a commanding officer. It's not anticipated that many of them would be dealt with at court-martial. The sentencing powers available at summary hearing are much less than those available at court-martial. An individual going in front of their commanding officer at summary hearing for an offence of conduct prejudicial to good order and service discipline can go there knowing that if the sentence is severe, or indeed if they contest the conviction itself, they have the option to take the matter to the court-martial summary appeal court. So most offences of conduct prejudicial to good order and service discipline are expected to be heard at summary hearing before a commanding officer, with the knowledge that if the conviction or the sentence is to be challenged, that can readily be done so through the court-martial summary appeal court.